Hello, landlords. It's Ernie Garcia, landlord attorney, and today we're talking all about getting sued. What do you do? Can a tenant sue you if they get sick on the rental property, and how should you, as a landlord, respond? We're talking that way. We're talking all about that today. We're going to wait a little bit for a few people to join in on the live, and we will get right to it. All right, well, got a few people jumping on here. We'll go ahead and get started. Today we're talking all about what potentially could happen to any one of you, you landlords out there who have rental property. Can a tenant sue you for getting sick in your rental property? Well, if a tenant believes that the reason they're sick is because of some condition on the property that you have control over, or worse, their claim is that you caused this condition, yeah, you can anticipate that a lawsuit may stem from any illness or injury that they experience because of the condition of the property. Now, what your lease has to say about that, what the facts may ultimately prove, are a different story than whether or not the tenant can do it. Here's a simple fact. Just about anybody can sue anybody for any reason in the United States. So whether that lawsuit has legs, whether it'll actually turn into a judgment, that's different. We don't always know that. In fact, many times lawsuits are introduced into the courts and they're kicked out because there's really no substance to them. And so what's important for you to know is, do you have a claim that a tenant has raised that does have substance? Is there something in that claim that you need to take seriously? Well, pardon me. Let's take a few things into consideration first and foremost. And right from the very beginning, has the tenant actually raised an issue that you need to address? Generally speaking, your lease is going to require that they notify you in writing. Has the tenant actually done this? And what is that issue? So here's a common one. They bring up the issue of mold, or there is some fume or odor that is, in the house. It's not mold related, but they really can't pinpoint it. There's something in the house that's making them ill. Another one has to do with things like pests, rodents, and stuff, some condition in the property that has a threat on their health or safety, and they've sent you notice. What do you do? Well, if the tenant has notified you of a defect on the property, then generally speaking, you've got a duty to do something about it. Now, what is a defect? Well, that's something that's gone wrong on the property. Sometimes things go wrong during casualty events. Fire, flood, some kind of windstorm, makes a property uninhabitable. That's a different set of facts. We're not really talking about that. When that happens, yeah, you got to act. And in many ways, if your home becomes uninhabitable after a casualty loss, definitely in the state of Texas, there's a provision in the property code that says you can simply terminate the lease and everybody's got to go. Unfortunately, these things happen. Hurricanes, tornadoes, floods, that sort of thing, fire. But instead, if there's some condition on the property that was not caused by the tenant, was not caused by some casualty event, it just erupts. There's some issue there that's making someone sick. So for example, the mold issue, there's the appearance of mold on the property. What do you as the landlord do? Well, very simply, you got to go and check it out. And so if you've never dealt with mold and don't have any experience with it, you may want to seek out somebody who does have experience to go take a look at it with you so that they can advise you properly. Let's say it's some kind of odor or some kind of rodent infestation. Well, what is the source? Is there something that you can fix on the property that would eliminate the problem. If there is, and it wasn't caused by the tenant, if this was just a condition of the house, maybe something allowed rodents onto the property that can simply be repaired and that problem eliminated, you need to act. And so you need to act with diligence. And diligence is really the key. What are you doing to make sure that your property is safe for your tenants? Now, once you've stepped in and actually taken care of the problem, what do you do if a tenant continues to say, I still don't feel safe? Well, if you've got people in there who have come in and eliminated the problem, the fact that the tenant doesn't feel safe anymore is not in and of itself the major issue. The question is, have you done enough to remedy the defect and eliminate the problem that was caused by that defect? If you have, but the tenant feels like it just wasn't enough or wishes you had done some other thing, they would have to prove that what you did was insufficient. They would have to prove that they are still in danger or that there is still some threat to their health or safety based on the continued condition on the property, and then give you notice and give you a suitable amount of time or a reasonable amount of time to deal with that problem. But without that, they don't really have much of a claim. Additionally, if after you've remedied a problem, the tenant doesn't have any medical evidence to support any of their contentions. They don't have a doctor that says, yeah, they developed a rash due to X, which was found on your property, or they have a respiratory illness due to Y, which was found on your property. Without something more substantial than just their opinion, they probably don't have the evidence to bring a legitimate claim against you. So the key is, if there's a defect, you have to deal with it. You have to deal with it diligently, and you have to resolve it within a reasonable amount of time. If your tenants have notified you of a defect on the property, make sure you're handling that. Make sure you're not just disregarding it or telling the tenant to take care of it. You could be setting yourself up for a lawsuit in that situation. Go to the property, figure out what the defect is, get the matter resolved quickly. And then if the tenant continues to complain about a situation that you know has been resolved, ask them what specifically still remains undone. And if what they're stating, again, just isn't going to affect the problem or isn't really indicative of an actual problem, they just would prefer an additional layer, an additional something, that might be your tenant being unreasonable. Additionally, if they claim all sorts of medical costs but have no medical evidence, it's unlikely that they have a legitimate claim for any kind of harm that they experienced. Again, every case is a little bit different, but if you do these basic things, you respond to notice, you act with diligence, you remedy problems as they are presented to you, and you communicate with your tenant to find out what has or hasn't actually transpired in the aftermath, you're going to be just fine. In the instance where a matter simply is beyond repair or beyond remedy, then you might have to be talking to your tenant about some kind of way to just get out of that lease. You sometimes have to get creative. Sometimes you need to seek legal counsel. And if that's the case, I strongly encourage you, sooner rather than later, find somebody who can help you out with that type of situation. But in most cases, 95%, 99% of the cases, it's something that you can remedy with your diligence. So I hope this was helpful for you. I hope you're able to glean some good information. I also want to entertain any of your questions you have. I have a few questions here that I want to answer for you guys. Anything that pops up during the chat, go ahead and add it to the chat, and I'll be happy to answer it as we progress. I see that James has joined us again. Good afternoon, James. Good to see you as always. So first question is here from Alexander. Alexander Valentine asks, I had a minor toilet leak upstairs. Just water drops about the size of a $50. Plumber came and mentioned to my tenant that there might be mold inside the space between the floor and the ceiling. So this is upstairs, between the floor and the ceiling, there might be mold. Tenant immediately told me that it must be the reason they had respiratory issues and said she'd be hiring an attorney to sue me. So this is one of those instances, and there's a little more that I'll get to in a second. This is one of those instances where there's a presumption that something's wrong. There's not actual evidence. Did anybody actually see mold? If nobody has actually seen mold, or no one can actually identify the presence of mold, then maybe mold is not there. Additionally, the tenant says, well, that explains my respiratory issues. And that may be legitimate, but if there aren't any doctor's reports, or there's nothing from some medical opinion that would back that up, it may not be legitimate. Still, diligence calls for the landlord to be responsive and to address the matter and to at least check it out. If the landlord's own technician came in there and said, yeah, there's a high likelihood of mold existing between the top floor and the bottom ceiling, then it's worth checking out. Alexander goes on, long story short, after $2,665 and several hours of labor, the water issue was fixed and it was confirmed there was no harmful mold. Here's the question. Do I have any chance of being reimbursed for those costs since her claims turned out to be unfounded? There's a second question. I'll get to that in a second. So first off, the fact that the tenant raised this issue means there was a problem that had to be checked into. The fact that there was no harmful mold found doesn't mean she was necessarily wrong. Just the presence of moisture itself could have left to her respiratory issues. I don't know. And we certainly don't have any expert testimony that refutes her position. And so in a lot of ways, some of these claims are just the cost of doing business. If there was a water issue that the tenant didn't cause, some water intrusion that could have resulted in mold, you have a duty to deal with that. You have a duty to make sure that your tenants are safe from the threat of mold. And so, no, I wouldn't say this is something that you could charge to the tenant. And I wouldn't say, and some of you might be thinking this, I also wouldn't say this is something you can charge to the technician. Now, frankly, I don't. In fact, I strongly encourage you to speak to technicians and say, please don't communicate with the tenants. You are my technician. I want to hear everything there is, the good, the bad, and the ugly. Share it with me. Please don't share it with the tenant, because I don't want you saying something that the tenant misunderstands or misinterprets or misrepresents later. By sharing all of that information directly with you, you can deal with the information, and then you can take the necessary steps as proposed by your technician. But the idea of your own person going out and giving their advice to the tenant, I'm not sure that that's the best technician for you. You might want to consider changing plumbers. He goes on, she's on a month-to-month lease, and I haven't raised the rent in over 5 years. If I raise the rent now, would it look retaliatory? So let's talk turkey. Is the reason you're raising the rent because you had to do this repair? That does seem like a one-for-one. And if you're directly relating the raising of a rent to her making a claim, then yeah, it could be seen as retaliatory. And what the code says is you can't do any of these things, which might have the appearance of retaliation, within 6 months of the act. So if you've gone 5 years, you can go another 6 months before you raise the rent. But I wouldn't push it. I would not put yourself in a situation where that claim can be made, because like I mentioned before, anybody can sue anybody. And as long as she has a colorable claim to make, she can survive summary judgment and take you all the way to trial. And if she's got a strong enough claim, she might actually win. And so you don't want to give your tenants the appearance that you're acting in a retaliatory manner. And part of this was just set up because it's not your normal business to raise the rent on a regular basis. It's too coincidental that you raise the rent in the aftermath of this claim. It's going to look like retaliation. Now, I always recommend to landlords that every year that your lease is renewed, you should be increasing the rent by at least 5%. In this case, if you haven't done it in 5 years, you've kind of lost out on 25 to 30% of an increase of the original rent amount, which is probably on par for where things are presently in terms of the rise in costs. Now, because of this claim, you're kind of stuck for 6 months. So make it your regular practice to raise the rent every year when there's a renewal, and then you can avoid this kind of situation. And I know you're probably thinking, well, I really liked her and I didn't have a problem before. You shouldn't raise or lower the rent you certainly shouldn't raise the rent based on problems. That is often looked on as retaliation. So steer clear of that situation. James says, let's say a tenant falls in your apartment, like in the bathroom, can they sue you? Yes, they can sue you. Now, whether or not they've got a valid claim to sue you from their own slip and fall in their bathroom depends on you, and it depends on the condition of the property. Let's say your bathroom is, for whatever reason, super slippery. You added some texture or somehow the flooring in that bathroom is unusually slippery. And you just left it there because you didn't want to incur the cost of doing anything to fix that. Well, that condition that you knew of might lead someone to injury. And if it is unreasonably harmful or unreasonably risky for anyone to be walking on that extra slippery floor, then yeah, it could be said that your action or inaction resulted in injury. But let's say everything's otherwise safe and someone drops an ice cube in the kitchen and grandma comes walking through the kitchen and slips and falls and injures herself on that kitchen floor because of someone else's negligence. That really can't be pointed at you. In fact, you should have a liability clause in your lease that says exactly the opposite, that unless it's something you did or failed to do, something that was not caused in any way by you, you have zero liability, and the tenant assumes full responsibility for the condition of the property that is not otherwise caused by you or was pre-existing. So thank you, James, for that question. Talus Red Star writes, is there a way to petition a judge for more time in moving out past the 30 days of the notice to vacate? I mean, the whole eviction process is potentially extra time beyond the notice to vacate. Generally speaking, in Texas anyway, your average eviction is going to last 30 to 45 days. Can you petition the judge for additional time? You absolutely can. Most judges won't give you the extra time, but in certain extenuating circumstances, I have seen judges who are willing to extend additional time. Again, in extenuating circumstances, if someone is, grievously ill or they're caring for someone who is very ill, sometimes the courts will give a little bit of extra time, but it's certainly not indefinite. And it's there's not an exact mechanism to guarantee that, except for your right to appeal. And so if you need additional time, every eviction can be appealed from the justice court to the county court, and that additionally extends time, usually 30 to 60 days, sometimes longer, depending on the situation. But but in terms of establishing something where the court is required to give you extra time, that just doesn't exist. Can they do it? Yeah. Should they do it? Again, it's their court and they can do basically whatever they want. But most courts won't, because you have these other things, other options that you can contend with, including an appeal. Most courts simply won't extend additional time. You'll be given what the statutory limits are, and then if you want, you can appeal and then have your matter heard in front of a different judge. So next question. Can an individual be sued even though the tenant was partially responsible for the condition on the property? So let's assume a couple of things. Let's assume that a landlord is being sued for, again, the big one is mold. The landlord is being sued for mold, and the mold came from an issue that was caused by the tenant. Let's say, for example, the tenant overflowed the bathtub and water went into one of the neighboring bedrooms. And that water sat on the carpet. The tenant didn't do anything. Maybe the tenant didn't know about it. Maybe it was caused by one of the kids, and they didn't tell mom or dad. They just kind of left it there. And eventually that soaking up of the water into the carpet led to a serious mold problem. Now, if the tenant sues the landlord probably has a pretty good defense that the tenant contributed to this mold. Now, where things get tricky is what happens if the tenant reports it to the landlord and the landlord does not act with diligence. They have a condition on the property that materially affects the health of an individual on the property, but the landlord just does zero about it. Does the landlord take on some liability at that point? And that's the big question, which is why it's always important for a landlord to act with reasonable diligence and to remedy issues that affect health and safety within a reasonable amount of time, even if the tenant is responsible for or partly responsible for that condition. So can you be sued? Yes. Might you have a defense? Sure. But if you do something to aggravate the problem, to make it worse by not responding with diligence, yeah, you might end up getting some liability in that situation. Again, if you had acted with diligence, you might have zero liability, but your failure to act with diligence might actually create liability where none originally was. James adds, we don't have a big problem with mold out here in West Texas, thankfully. Right. And so maybe it's not mold, but there's all sorts of other things that pop up that are conditions on the property that sometimes lead to health or safety problems that tenants are going to try to take out on the landlord. All right. Talis Red Star says, LOL, not so here in Southeast Texas. And that's just true. We live in a mold. I tell landlords this all the time. We live in a moldy area of the country, very warm, very moist. And so the effects of mold are pretty high all over the place. And so most people know how to deal with it, or most people are used to it. The real problem comes when a water infiltration, it goes unaddressed for a long period of time. And who ultimately has a responsibility for that? If it's from a water leak behind a wall that is, undetectable by the tenant, that results in, a ton of mold that affects the health of an individual, yeah, that's not something the tenant caused. And so if it results in, problems for the landlord, the real question is going to come down to, did the landlord have some responsibility when it came to that leak? Well, you would think, well, normally no. I mean, leaks happen, and through no fault of anyone, stuff just wears out. And if a leak sprung up, the question for the court might be, when was that leak discovered? And did the landlord already know about it, or should the landlord have known about it? Or let's say the landlord was the one who actually did the work and did a poor job, installing a pipe or maybe repairing a pipe. And that poor workmanship ultimately led to that leak, which led to health issues with the tenant. All those could be contributing factors that landlords should take seriously. Okay. All right. Okay. And our final question. All right. So if a tenant is delinquent on rent when they report a defect on the property, am I, as the landlord, required to conduct that repair? Now, I know a lot of you have a lease that may have a clause that says this very thing, that if the rent remains unpaid, the landlord is under no obligation to conduct a repair. And while that may be in the black and white of the lease, courts don't like that, particularly when there is some big deal that the landlord can resolve, they're going to shift the duty to the landlord to do something. And I always recommend, for a couple of reasons. Number one, this is your property. You want to maintain it in good condition. But number two, you don't want to give the tenant a claim or to strengthen a claim that a tenant may raise against you just because they didn't pay you rent. It's just not a good enough excuse for you to kind of leave the door wide open for them to ultimately sue you, because the rent loss might be here, but the injury could be up here. And a court could say, fine, I'll reduce this injury by that much to compensate you for the rent, but you still have all of this to pay because they were legitimately injured. And so I don't know that it's a good trade-off. And while your lease may say that, I wouldn't rely on it. If there's a serious risk to bodily injury or harm or illness, act with diligence, take care of it, make sure that your tenants are safe and that you're free from, potential claims. So that's it. We don't have any additional questions that were presented to us ahead of time. And I don't know that we have any additional questions on the live stream. It was a short one today, about 30 minutes. I do want to thank all of you for joining us. We'll be back next week, and I can share our topic. Let's see. So next week, we're going to be talking about how can I increase my rent without it making it seem like I'm being greedy. What can you do to reasonably raise your rent? We're going to talk all about that next week. Until next time, landlords, happy leasing.